Adam Levine is our next presenter, so our heart-to-heart conversation continues.
Thanks very much. I do have one bit of bad news. I'm not actually Adam Levine. Okay. I know everyone loves the singer, kids, grandkids. I'm Adam Rubin. So I hope if you were coming here to hear some songs, if I finish quick, I'll sing, but otherwise we're going to talk about estate planning. And we're going to talk about how estate planning is important for everyone in this room, okay, and what you need to know. Because, you know, similar to Dr. Adam, you know, and he made the joke, he said when he said what he does, all the misconceptions he gets. Well, when Adam Rubin talks, the number one thing I hear is, I'm an estate planning attorney, the first thing that everyone says, and if you can't hear me, let me know. I'll adjust the microphone. But the first thing everyone always says is, oh, the will guy. But there's so much more you need to know about estate planning than just wills. You know, there's so much more you need to know about the importance of protecting yourself, making sure your wishes are accomplished, than just a will. So there's a lot to get through. So what we did is I prepared a handout, or can't steal credit. Tony, the office manager in the back, prepared a handout for everyone. And what we did in that handout is we broke estate planning into 4 categories, okay? And these are the categories I think everyone needs to know. Now, I'm not going to dive too far deep into any category, but because you can ask questions, but at least this will have you thinking about the right things. So when you go home, when you assess, you're going to say, are we okay? Are we protected? Or do we need to do something? Okay. Now, the first layer about estate planning, again, we'll take care of the family. We're going to go over all of that, but we got to worry about our number ones, you. Okay? So we have to make sure that you're protected with the right planning documents. Okay? Now, has anyone here heard of a guardianship? Oh, wow, a lot of hands. Okay, and who wants to take a guess at saying what a guardianship is? We're not grading anyone, don't worry.
Control over minors.
Okay, so the one element of a guardianship that most common is to control the minors, right? If there's little kids and if the parents aren't here, we do a guardianship to control the minors. But sometimes a guardianship applies to adults. Has anyone heard of it in that context? Absolutely. So guardianship, and like any lawyer, I'm not going to say a bad word about the court, but collectively, we don't want the court to be involved in our estate plan. Because then you're not making the decisions, right? It's done by court. And we're guessing. So guardianship is the court process to appoint someone to A, manage your affairs financially, and B, make health decisions for you. So a lot of times we have a client who's rushed to the hospital and they didn't have any planning done, right? And sometimes the physicians, the doctors will say, you know what, we'll talk to the wife, we'll talk to the kids. But a lot of times with HIPAA and certain regulations, they need to see paperwork. And if you don't have that paperwork, we have to go to court. It's a delayed process just to get someone appointed. So how do we avoid it, right? The 2 most important documents I think you need, okay? And we're going to be talking about a lot of paper, that's what lawyers do. But the number 2 things everyone in this room needs is a power of attorney and a living will healthcare directive. Now, who knows what a power of attorney is? You wanna?
Oh, it's if you can't make the decisions that you appointed somebody to make certain decisions, financial or whatever, for you.
Okay, and don't worry, I'll repeat it because I have the mic, she doesn't, but that was fabulous. A power of attorney is a document where if you can't make your financial decisions, you're outlining who's going to make them for you. Okay? It's an incredibly important document. Okay? And to be honest, you can get it for, it's not $15,000 to get a power of attorney done. You can get it for a very reasonable price. But it's going to make such a difference. Now, has anyone here heard of a living will healthcare directive? In New Jersey, it's 1 document. Okay. We'll give someone else a chance. You raise your hand? All right, you can go again. Yeah.
A living will is you assign somebody who knows you've already spoken to them and they know what your wishes are whether you want to be on life support, whether you don't want to be on life support, whether you want to donate your organs, whether you don't want to organs. But they know your wishes and you've appointed them to make those decisions for you.
Okay, in case anyone didn't hear, that was fabulous, thank you again. A living will is a document where you're going to outline your healthcare wishes. So what you want to happen under certain circumstances. And in New Jersey, you also in that document, you appoint someone to talk to the doctor for you. So it serves those two purposes, right? And I can't tell you how important that is. Because when that document's needed, you can't talk. You can't say, Dr. Adam, do this, Dr. Adam, do that, right? So we need your wishes outlined so the doctors know what they're supposed to, what they can do, what you want. A client once told me this, and I'll never forget it. A client said, that living will is the best gift I'm giving my family. And think about it, right? I don't know, hopefully a lot of you haven't been in that situation where the doctor's asking you, what do we do, what do we don't do? For someone's end-of-life treatment. But think about the blessing you're giving if there's children involved, a loved one, a family member, and outlining your wishes for them. So they're not there guessing what you wanted to have. They don't have the wrath of their siblings saying, why'd you do that? Mom wouldn't want that. So those two documents, again, it's all about you, numero uno. And that's the first layer of planning. We'll get to the wills, we'll get to all the fun stuff, but you gotta take care of number one. Everyone knows it. Now the second layer is, well, who here likes taxes? Someone, no? Usually there's, oh, here, he likes it. Everyone send your tax bill to him. He said he likes taxes, all right. We're gonna make you real happy this year. Okay. The second thing that we have to talk about, and we're gonna touch on this briefly, is death taxes, okay? Because so many people always wonder about this, and I just wanna clear the air so you leave here with a good education, right? First, does New Jersey have an estate tax?
Yes, yes.
No.
If you're not a family member.
That's the inheritance tax.
Oh, that's it.
So New Jersey, for the longest time, they always had the articles, why New Jersey's the worst place to pass away, right? Well, a couple years ago, in about 2017, they eliminated the estate tax. So for the longest time, it was the 675 number, it's gone. So pick your favorite billionaire, right? If Bill Gates passed away in New Jersey, there would not be a New Jersey estate tax. Now, New Jersey does have an inheritance tax. That means that if you leave assets, and I always call this the flight attendant tax, because if you leave assets to a spouse, or children, or parents, the inheritance tax does not apply. You're A-OK. But if we start leaving assets to cousins, nieces, nephews, friends, our next door neighbor, they're going to pay tax. And that tax rates, the rates vary, but they're between 10 and 16%. So it can get, you think that's bad? Wait. The federal, there's good news and bad news on the federal side, right? Federal right now in 2023, we can each leave $12.8 million to our families free of tax. No questions. Cool, right? If they go over that amount, does anyone want to guess the tax rate? 40%. Okay? Yeah. It's a big ticket. So if anyone here is over 12.8 million, get ready, it's coming. Now again, that's always subject to change. In a couple of years, it's actually going to go down. But just keep an eye on it because 40% is a big ticket, right? Immediate family, sure. For immediate family for the inheritance tax would be parents, grandparents, spouse, children, and grandchildren.
What about stepchildren?
Oh, this is a great question. So, and I'm a Jersey boy through and through, I tell you. I always make the joke we do presentations. I'm a Jersey Shore guy. I mean, my perfect day is Bruce Springsteen and a windmill hot dog. But, that being said, I have to knock our state. Stepchildren are considered immediate family. And no one understands this, so don't ask me to explain it. Step grandchildren are not considered immediate family. What do you want me to say? I have nothing.
Who pays the tax on the inheritance tax for people other than the immediate family members? The receiver or the distributor?
Okay, so the question is, if there's a tax to, you want to leave, if there's a tax due, that inheritance tax, who's responsible for paying?
The person receiving.
It depends on your will. It depends. Because the will can say, I want it to come out of the pot, or the will can say they should be responsible for it. So you need to outline that in your documents. Okay, but you can do that. Now, tax is one that always everyone loves talking about right before lunch, right? Okay, now, who here has heard of a will? A will. Question for you, because this is one of those that tricks everyone. Does a will have to go to court? If you want a will, if a will is needed and we have to use it, it absolutely goes to court. The process is called probate. We've all heard of probate, right? Now, probate is a court process. It's not like you think on TV where you have the lawyers in the suits standing and, OJ's on the trial. No trial, none of that shenanigans. But it still is a court process. Now, New Jersey has the third easiest probate in the country. But there's still reasons some people want to avoid it. One, it's public. So a lot of people nowadays with all the, scam artists and the shenanigans, they want to keep everything private, right? So if you want your affairs private, then you can't, understand your will is going to be public when you pass away, right? Also, there are delays with probate. Again, New Jersey is one of the easiest ones, but it might take time to distribute the assets. So you have to understand, this is why some people don't rely on the will. The alternative, if you don't want to do a will, is a lot of people do a trust. A trust, as I mentioned, is an option, it's an alternative to a will. And it's a way, I'm a big fan of it, I have one, but the reason I love my trust is it allows for assets to be distributed without any government interference, right? So it allows right away, there's privacy, and things can be transferred a little quicker. Now, when we're not here, again, a lot of times, my big emphasis on my job, the scariest family for me to work with is someone who says, Adam, we have 2 kids, we love our in-laws, that everyone's best of friends, everyone gets along. Because that's a lot of pressure. Because I have to make sure that when you're not here, the family still gets along. So that's why, whether it's a will or a trust, that document has to be clear. We have to know what mom wanted, what dad, what uncle, whatever it is. We can't leave the mystery because we can't ask you at that time. So in those documents, we're going to outline your wishes. We're going to talk about who gets things at different times, right? We're going to talk about it, and we're going to protect it, I have a 5-year-old and a 2-year-old, 2 little redheads. I don't know if my kids, I always tell the joke, don't tell my parents this, but I don't know, guys, of course, I don't know if my kids are going to Princeton or prison. Right? It's unfortunate, but I hope like all you, right? But so we can put protection in. Like my kids and my documents, they're not getting the inheritance if I pass before the age of 30. 30, yeah. Because I don't want my legacy to be that they, at 18 said they're trust fund babies. I want them to work. I want them to develop those roots.
Tough love.
Tough love. Who knows Johnny McEnroe? John Mack, right? Tennis player?
Yeah.
You know what he said about his kids? They asked him once, they said, Johnny Mack, are your kids ever going to be pro tennis players? And he said, both of my kids suffer from a really bad disease. Anyone want to guess that disease?
Affluenza.
Woo! Who said that? That was his exact word, affluenza. So he said, so that's a thing, whether you're leaving inheritances to kids, grandkids. We want to make sure your legacy is protected in outline. So that's why I went with the tough love trust.
All right.
A lot of people, the most common protection I do is divorce protection. Does anyone want to guess the divorce rate right now?
60%? 60?
Yeah, 60, 62. So you have better odds of winning. If you think about it, I think you have better odds of winning a blackjack hand in Atlantic City than your marriage work. Is that crazy? But so we do a lot, and I think this is a big deal for those children of ours, those grandchildren. We do a lot of divorce protection, right? Because how cool is this? Like, if you have children, we're going to make it where they get full access to their inheritance, right? Feed, protect, not punish. But if, God forbid, they ever get divorced, the inheritance is not shared, right? Mm-hmm. Or how about this? If your child passes away, the inheritance passes to the grandkids. Not son-in-law, not daughter-in-law, just keep it in the blood, right? I'm a big fan of that, you know? We like it. Another protection we do when our loved ones aren't here, or when we're not here, is creditors. A lot of times we have to protect your child or your loved one as bankruptcy issues, creditors. You just don't want your money going directly to them. So we can set up an inheritance where it's protected, right? So I'm just, and this is a deliberate flyover, right? We're not diving in. I don't have the chalkboard up. I'm not saying here's how we do it. I just want you to understand. When Scan invited me, when Michael was nice enough to include me in this amazing event, it was lunch and learn. So we're focusing on the learn, right? I want you to have that understanding. So if I'm not going into enough detail, don't worry, but I'm just identifying issues that you need to be thinking about, right?
I have a question.
Sure.
If you leave in your will, like your son or your daughter, their portion, does that go, what happens if they get divorced?
So, it depends. You know, I love my area of law because it's very, very black and white. I can say this goes to probate, this is taxable, there's always an answer. Divorce is a lot more gray area, right? I mean, if you talk to a divorce lawyer, the first thing they'll say is the inheritance should be protected as long as it's kept separate. But you get into a lot of gray areas because most people take their inheritance and they put it into a joint account. Then you lose all protection. Okay. Or if it's inheritance and it's, let's say they inherit a house and the spouse is contributing, it can get very gray. So we're a firm believer in locking it up, taking that extra layer, removing the gray. Okay?
Thank you.
Of course, you're very welcome. Okay. Now, one more layer of protection we want to talk about is, has anyone here heard of a special needs trust? No? All right. So many times people say, Adam, I have a niece who's on government assistance. They really could use the money, and I want to leave them something. Right? And what people don't realize is if you leave someone on government assistance and inheritance, that inheritance could be one of the worst things to ever happen to them. The inheritance is going to knock them off all of their government programs. They then have to wait 6 months to reapply just to get back to where they are. What we could do with the special needs trust is we could put it in a way where it's going to keep them eligible for all their government assistance. Okay, it's going to help them. It's going to go above the government assistance. And that's something like, if you tell me, Adam, I'm not crazy about the divorce protection, fine. But if you have anyone in your life who's on any government assistance, okay, you have to do this because it could be, that inheritance could be one of the worst things to ever happen to them. So we got to look out for those loved ones. Okay. And you could put it's terrific what we could do with estate planning now. We could, if needed, we could put in, they have to go to counseling for gambling. People have to have a job. If God forbid, substance abuse is a major problem nowadays, right? And last thing we want is inheritance to hurt someone. So we could put in planning for that, right? Now, The next layer I want to talk about, okay?
Before you go to that, can I
Yes,
ask
please.
one other thing about the bloodline? What about adopted kids? Because you talked about adopted, step-grandchildren. What about the grandchildren of adopted children?
So, okay, just to clarify, if a stepchild's adopted, it doesn't count as a stepchild anymore. It becomes a child. But in general, about adopted children. So, and this is why, that's a fabulous question, amazing. Because this is why it's so important those documents are clear and understanding. I can tell you my documents, by default, include adopted children. But in every single meeting we have, we talk about that. Are there any adopted grandchildren? Are there any adopted children? Because you have the right to define whether or not they get funds from you. But imagine if we're not clear, imagine if the document's silent on that and you're not with us, right? But you have the right to define it, okay? Now, next thing I wanted to talk about is long-term care planning, okay? Long-term care planning. Who here's heard of Medicaid? Everyone, right? So I'm not going to ask you to define Medicaid because I'll say this first things first. Medicaid is not Medicare, okay? Because so many times people get those confused. They're very different. We're here to talk Medicaid, all right? Now, Medicaid is an amazing government program that absolutely will help pay for your long-term care expenses, okay? But for a single person to qualify for Medicaid, how much can they have? Wow, this gentleman said it, $2,000. If you're married, the non-Medicaid spouse can keep closer to $120,000, all right? Now, we have really smart clients, and they all come in, and then when I start talking about Medicaid, they all start laughing, and they know, I know a trick, right? And they say, when I'm ready to go to a nursing facility, I'm going to quickly have my daughter, I'm going to put everything in her name, and then apply for Medicaid, and get full government assistance. Is that going to work?
Nope.
Wow. Whew. Good. Because Medicaid looks back, right? And how far do they look back? 5 years. Yeah. Not 7 yet, 5. So what that means is, if I'm going to apply for Medicaid on, what's the date, 16th? I knew it was the 16th this morning. Right. If I'm going to apply for Medicaid on the 16th in 2028, they're going to look back. They're going to have us submit every bank statement, right? They're going to look at car titles, everything. And if you made any transfers, you'll still qualify, but they're going to penalize you. So you get a letter in the mail that says, congratulations, you're eligible, but not for 5 months, not for 7 months, right? She went through it, yeah. So a lot of times when we do Medicaid applications, right, we need to submit a whole application. Now, some people transfer assets. I always say it's really a personal choice. I can never tell. At the end of the day, when I'm sitting with the client, right, if they want, I can help. If they want to protect funds, I can help. But I'm never going to push that because that has to come from you, right? Because at the end of the day, when I'm sitting with a client, an elder law client, you know, if they say, Adam, I want my kids to get everything, I'm willing to give up control, we'll do something. And if not, that's okay as well. You know, because at the end of the day, it's yours. Again, the theme today, well, obviously it's a lunch and learn. The theme about this part is the learn. Now, the VA, are there any veterans in the crowd? Thank you for your service. Thank you. So the VA, believe it or not, has tremendous benefits. And you have to be aware of them so you can unlock them. Because they have funds ready to be distributed that can help long-term care. Okay? One of the most popular programs is a program called Aid and Attendance. Okay? And if an individual qualifies, you can receive basically a monthly allowance to apply to long-term care. Right? Now, it's based on your assets. It's not $2,000. For that, it's significantly higher. okay? And to qualify, you had to serve during wartime and leave the country and not be dishonorably discharged, okay? So, and it's a tremendous program, you know, there's certain VA benefits which, you know, veterans are entitled to. So, it's very relevant, just based on, if you look back at the ages, the periods when we were at war and the ages of some of the people as, there was, back 50, 60 years ago, we were active in a couple wars, so that's why that's very relevant to talk about. Now, I can dive deeper, but I wanted really to share the platform. I don't know time, if I'm okay if I...
Another like 4 minutes. For
4 minutes?
Q&A, yeah.
Okay, so I can dive deeper into any of these topics. You know, it was deliberate that I did the 30,000-foot view, just so you can understand it, so you can recognize it, so you can smell it if it's a problem. But if there's anyone has specific questions, I want to take them now. Otherwise, I'll keep going. Trust me. It's never hard to get a lawyer to talk.
She's got it.
Yes.
So what should a single person, never married, do to avoid her nieces and nephews and grandnieces and nephews and siblings to avoid the tax?
Okay.
I need to come in and see you.
Yes. So the question is, and I can repeat that, correct? Yeah. The question is, I'm single, never married, I believe she said, and I want to leave assets to siblings, nieces, and nephews. How do we avoid the inheritance tax? Unfortunately, in New Jersey, the only way to avoid the inheritance tax would be to give away the money 3 years before you pass away. Okay? So it's a little bit of a lousy situation, but, you know, and again, I tell them, my thought, and I'm a tax attorney, but my thought is sometimes under those circumstances, it's okay to pay the tax because I don't want to see you give up control of your assets. We never want the tax tail to wag the dog. So I can help plan to get rid of those taxes, but it means you're giving up control. There's no smoke and mirrors.
If you were to give away the money and start early in the separate accounts, like say with a rent check, and then you buy it after 5 years, instead,
Okay, so the question is, if you give money away to grandchildren, and then you pass away, or no, well, the look back only applies for nursing care. Sorry, I misunderstood.
bank in their name.
If you put money into grandchildren's names, and then 6 years down the road, you go to apply to Medicaid, will Medicaid look at that money? As long as your names are not on the account, okay? Like a big myth that we have is everyone goes around and they think Medicaid planning means I'll just add my kids to the account. I'll add someone to the account with me. You have to get your name off of those accounts if you want to protect it. Okay? It can't be a mutual thing. I think I saw another hand.
Explain the POD, pay on death, and does it avoid probate?
Okay. So POD, TOD. Transfer on death, payable on death. A lot of the financial institutions, you know, allow you to do that with your accounts. What that means is when you pass away, that account automatically passes to the people who are it's payable to. And it doesn't have to go to court, so you can avoid probate for that account. But it just takes one account, one asset for a probate. So a lot of times people come in and they say, I made every account I own POD to my children. And they're so proud, right? But their house is in their name. So it doesn't matter, we're doing a probate anyway. You know? And also the other risk with POD, TOD is a lot of that, I think it's cool, protection we talked about protecting from divorce or making sure the kids don't get it when they're too young. You can't do that with POD, TOD. It's passing to them outright. But yes, if you're a renter, right, and you have, only asset you have is a bank account with $100,000, and you put your children on it, then there shouldn't be a probate when you pass away. Should not. Okay, good. Thank you.
Thank you, Adam.